It's a scam, Mr. Dotto.
That scam, what they say, scam, please see whether at all there was anything in the petition.
No, no, right. You have
Yes,
showed us
yes, yes.
that there was
Nothing
no
was
meeting.
there. Milord, simply, Milord, using this catch expression, scam, corruption, scam, corruption, doesn't mean that a case is proved. A case has to be proved even if it is scam.
So there will be no perception of the judge.
Milord, in that case, Milord, the judge should first release the matter.
First,
Release the matter with
the
respect.
perception in the sense from the record.
Milord, no,
not
no,
his
these
own
are not on
perception.
record. Milord, these are the personal views of the judge. 2014 was published, but no merit list and scorecard was given to anyone. On 26/9/2016, notification was published for appointment of primary teachers from TET 2014 to fill up 42,949 vacancies. In that notification, it was clearly stated that candidates with minimum qualification as specified by MHRD will get preference, and after that, eligible candidates with relaxed qualification may be considered. Or in other words, Milord, first the trained candidates will be appointed, and for the rest of the vacancies, untrained candidates. That was the relaxation. It is needless to mention that MHRD gave relaxation only till March 2016, and in spite of that, the board notified that the candidates who do not have the training will be considered too. The notification proves that the board decided to give uh, something of the relaxation benefits of relaxation to all TET 2014 qualified candidates. Your petitioner states that after the notification, the procedure was started for appointment from October to December 2016. The interview and verification started on 31st of January 2017. Allegedly, the merit was declared, but there was no panel, there was no merit list, there was no category wise, merit wise, no division of numbers, and or rank was given to anyone. In website of the board, there was a dedicated space where the person could see whether she was impaneled or not. No merit list was ever published, and in spite of repeated requests, the full merit list was not made to the public. Allegedly, it was stated on 31/2017, list of trained candidates were published. On 4/2/2017, list of non-trained candidates other than the Bengali medium was published, and on 8/2/2017, list of non-trained candidates and candidates from Bengali medium were published. From the dates and the list, it is clear that all trained candidates of TET 14 were appointed through the first list, and after completion of the same, as per notification of 2nd March 2016, the board appointed non-trained candidates. The board stated that they shall publish more lists, but those lists were not published. Your petitioner state that on so and so date, notices were published for recruitment as assistant teachers in primary schools from TET 2014. The board has appointed non-trained teachers after 2016 even, and intentionally ignored the petitioners by giving excuse of notification of MHRD by way of so and so dated 9th of April 2015. Thousands of non-trained students were appointed, and petitioners, those similarly placed, were ignored. But this is the only case. Petitioners who were similarly placed were ignored.
They were also non-trained.
Untrained candidates or non-trained candidates. Untrained. If it is the stand of the board that no non-trained candidates can be appointed, then all the appointments of non-trained candidates made after March 2016 are bad in law. The relaxation given by the NCTE is applicable to all in any TET 2014 candidates who qualified in the examination.
So the board appointed untrained candidates. The petitioner says that I am also an untrained candidate, but you have not included
me, or you have given deprived me and given appointments to other non-trained candidates. But this is the short case. Now this has been stretched to I should say, Milord, and illogically extended, Milord, adjudication of the matter. Your petitioners state that recently the TET 14 scam busted in West Bengal, and from several cases lodged by CBI and from several orders passed by this court, the petitioners came to know that several illegal appointments have been given by depriving the petitioners. Non-trained candidates are the worst sufferer of this scam. On 23rd December 2020, the West Bengal Board of Primary Education published one notification of recruitment of 16,500 primary teachers. This is the subsequent recruitment process. I don't think I need to trouble your lordship with this part. Then 13 Millard, they give examples of 4 persons who were allegedly non-empaneled, but they got appointment. And then Millard, kindly take Millard, paragraph 14. Your petitioner states that at present, there is more than 1 lakh vacancy in the education department. Since 2011, several examinations were conducted to fill up the vacancies in the school, but a single recruitment procedure could not be completed without corruption and irregularities. The qualified students were not selected. These are all prejudicial facts. Then, Millard, paragraph 15 is one honorable member of the parliament had made certain comments. The others are MLAs who have made certain comments. Then paragraph 16, biggest scam. TET 14 is the biggest scam. Para 17 again, TET 14 is the biggest scam, and 14 to 20 lakh rupees were exchanged. Then kindly take Millard, para 18.
So you were unsuccessful in TET?
The writ petitioners. No, they were successful in TET, but as your lordships know, Millard, TET is a qualification for applying as for recruitment for the.
So they passed TET.
Yes, so far as passing of the TET examination is concerned, there is no dispute.
Now they are saying that TET
that they have been, yes, what their case is that they also fall within the untrained or non-trained category.
Who were not successful in TET?
No. Everybody are successful, because unless somebody is a TET qualified, like I can apply for enrollment only if I pass the LLB degree course, or I can apply for judicial service provided I pass the LLB course. So therefore, TET is like a qualification, is one of the eligibility criteria. Your petitioner states that the board has started different cases before this court, that 42,897 candidates were selected till date, but no merit list of the candidates were ever published by the board. The board should be directed to publish a merit list by disclosing the numbers obtained in written interview, and a reservation category wise list should be published. Candidates were informed through SMS, and no merit list of so and so candidates were published, and it proves the mischief in the recruitment process. If the process was free from all corruption, then there ought to have been a transparent merit list of so and so. The process was not completed in February 2017, and the department is well aware of the same, and this honorable court should take notice of the same. Persons who did not qualify for TET 14 were appointed as primary teachers, but these are all Millard submissions without any proof whatsoever, any evidence whatsoever. Be that as it may, I will deal with each of the allegations. Were appointed as primary teachers by the board, and in spite of specific case, steps were not taken, and it shows that there was corruption and illegal financial transaction while conducting the recruitment process. The department ought to have given suo motu steps, but that was not done for the reasons best known to them. Moreover, many candidates complained that TET 14 qualified candidates were not issued to them, and even today they were fighting for that. There is no delay in filing the PIL, etc. I do not know from where Millard they have copied this, but this is there. Then Millard, para 19. The petitioners state that your petitioners are hailing from poor families, and if they were recruited in time by giving them opportunity of being trained, etc. I don't think that these are that important. Then para 21, 22, they all speak of corruption everywhere, and then are the grounds. Now, what is very, very important is the prayer and the date of affirmation of the writ.
So you tell us what was their pleading based, what were the arguments they were advancing?
Millard, I can speak of the argument provided, Millard, the proceeding was confined to or limited to the pleadings, and Millard, the affidavits in opposition and the replies.
And according to you,
yes,
there
was no argument.
What were the contentious issues?
Millard, there were no argument. Now, Millard, I'll place the judgment. There was no argument.
No,
but I would start from placing judgments before this court that what is meant by a judgment and what should be the characteristic of a judgment.
No, according to you, Mr. Dotto, on the pleadings, what were the infirmities they pointed out?
My lord,
Just
the
point one was untrained, similarly situated, not
but this is the only part.
no merit list was published.
No merit limit, that my lord, I'll satisfy, my lord. Yes.
Third is there are discrimination among certain persons.
3 or 4 examples were given. 3 or 4 examples given.
So primarily it is think that I am unsuccessful.
Yes.
So you turn down the entire.
No, that was not the prayer. That was not the prayer. Now please have a look to the prayer. But I will take your lordship, my lord, from the very first order which was passed in this writ petition. But this matter has, my lord, very many facets for your lordship to decide, in addition to the merits of the matter. And
It has not come up in appeal against
no,
this.
because the entire recruitment process is conducted by the board.
State is also
Conducted by the board.
Yes, show us what you are showing.
Yes, now kindly have a look to the prayers. 47. At page 47. Prayer A is Rule 26 dispensation. Prayer B. A writ of in the nature of mandamus be issued directing the respondent authorities as follows: to act in accordance with law, to direct the authorities to file a report disclosing name, numbers, rank, category of all non-trained candidates who have been recruited till date in primary schools from TET 2014, including the date of recruitment. To direct the authorities to treat the petitioner equally with the non-trained candidates who have been recruited by the board after expiry of the relaxation given by MHRD on so and so. To recruit the petitioner by giving them the same benefit by which the other non-trained candidates were recruited by the board by following the rules dated 2nd of March 2016 and appointment notification dated so and so. Direct the authorities to publish a merit list by maintaining full transparency regarding TET 2014 recruitment to protect the records, etc. Sasha, right. And my lord, in this writ petition, my lord, 36,000 appointment has been set aside without any prayer.
Yes.
The date of affirmation is very important. 12th of September 2022. In respect of a recruitment drive in the year 2016.
When was the last appointment made?
Last upon 20.
February 2017. Apart from
Please ask your junior to.
Yes, 2017 February. But in addition to that, Miller, there are certain court orders. Under court orders also appointment made, but
Subsequent to 17.
subsequent to 17, but these are all under court orders. But so far as the board is concerned, in the recruitment process, the last appointment was made in February 2017.
recommendation.
Or recommendation.
Yes.
Now, Miller, I need to, Miller, take your lordship, Miller, through the orders passed by the learned single judge from the day of entertaining the writ petition. But judgment period under appeal, Miller, I'll come later on.
Yes.
Miller, your lordships may kindly take me the third paper book, page 418. আচ্ছা আমাকে পেজ নাম্বারগুলো বলে দিতে পারি। হয় 2/22 কত তারিখ? কত পাতা? 6/2/22
418.
6/2/22
415 it starts.
415.
তুই আমাকে 6/12/2022 পাতাটা বল। Please take me at page number 415 first. This is dated 6th of December 2022.
Yes.
The petitioners appeared in the 2016 recruitment process. All of them are TET qualified, as has been submitted from the bar and pleaded in the writ petition application. The petitioners came before this court after the documents and marks produced before the division bench headed by the Honorable the Chief Justice in one of the matter which was first moved before me, and I adjourned the matter seeing the nature and character of the same as a PIL and sent it before the Honorable the Chief Justice.
This is not the writ petition against which this appeal.
By the West Bengal Board of so and so and the respective councils, the petitioners given a large number of candidates were appointed who got marks below the petitioners. The petitioners got this information from the learned advocates who inspected the concerned list. The petitioners submitted despite their marks being higher than the untrained candidates of 2016 and were called in interview and aptitude test. None of them were called in the interview. Learned advocate for the West Bengal Board of so and so has drawn my attention to the prayers and have stated that in one prayer the petitioner has prayed for publication of some information which are already in public domain. But I am told by the petitioners that the petitioners' breakup of marks are not in the public domain, as the candidates who were recommended, only their marks have been uploaded. Learned advocate for the board has also raised the question as to whether the petitioners applied for the recruitment test of 2016 and whether they were called for interview at all. After considering the submissions of the parties, I direct the petitioners to disclose the application filed by the petitioner and call letters for interview of the petitioners by filing supplementary affidavit. The petitioners shall also disclose the documents as to their training qualification, if any, taken by them. The training qualification documents, if any, shall also be disclosed. Or Miller, the court is inviting documents from the petitioners. Why this is important, Miller, as I progress, your lordships would find. Kindly take the next order of 20th of December 2022
418.
at 418.
Yes.
The case of the petitioner in short is that though the petitioners got higher marks before addition of marks against interview and aptitude test, comparing to some of the candidates who have been given the appointments against 2016 recruitment process ever after adding their marks for personality test and aptitude test, they have not been given appointment. Please mark this last sentence of the court. The petitioner's case is that interview was also held, aptitude test was also taken. But why this is important, I'll come later on, because the judgment proceeds on the basis that no aptitude test was taken and the honorable judge had called witness, cross-examined the witnesses. A complete unknown procedure. Allegedly in exercise of power under section 165 of the Evidence Act. But please mark this sentence that it is the case of the petitioners that it is clear that the board and its officials, including the former president who is now in custody so and so, conducted the whole affair like affair of a local club, and now it is gradually coming to light by investigation of Enforcement Directorate that jobs of primary school teachers were actually sold to some candidates who made money to who had the money to purchase the employment. A corruption of this magnitude was never known in the state of West Bengal. A former education minister, the former president of the board, and a number of middlemen through whom the jobs were sold like a commodity are now behind the bars, and the CBI ED investigation is being continued now in full swing. With respect, Miller, paragraph 17 has got nothing to do with the merits of the matter.
It's a scam, Mr. Dotto.
That scam, what they say, scam, please see whether at all there was anything in the petition.
No, right. You have
Yes,
told us
yes.
that there was
Nothing
no
was there.
that
Miller, simply Miller using this catch expression, scam, corruption, scam, corruption, doesn't mean that a case is proved. A case has to be proved even if it is scam.
So there will be no perception of the judge.
Miller, in that case, Miller, the judge should first release the matter.
First,
Release the matter with
the
respect.
perception in the sense from the record.
Miller, no, these are not on record. Miller, these are the personal views of the judge. But how could the Honorable Court get the name of that third agency?
If it is ultimately shown by them that they are
Whether it is shown by them, right?
these are all factors inextricably bound. You cannot segregate it without.
No, these were not placed before the court. I'll come to all the pleadings one by one. It has to be there in the pleadings.
The pleadings you have shown. Pleadings you have
Nothing is in the pleading. I'll come to the other pleadings. I've just taken your lordship through the writ petition. Other things where and the sequence of pleading is also very important. When did the court invite which pleading? That is also very important. Where I have a short list of dates for that also.
So that we will hear. We are
Yes.
just interacting with you.
Right.
We are
Definitely.
asking you
Yes,
that
yes.
when there is such a heart-throbbing issue of scam, which you say that it has to be different definitions can be given. But it is a fact that there had been a scam in respect of several education.
But that will not, my lord, vitiate the other selection process. My lord, one selection process said to be bad doesn't mean, my lord, the other.
Can be argued against you that in order to divert from that issue, you are taking up the very basics as to whether there were any pleadings. Maybe this may be an argument on their side.
Yes, yes,
also.
definitely. Yes, yes.
That.
But I will deal with those also.
Yes, yes, yes.
But
Yes.
otherwise, my lord, the whole, my lord, the writ jurisprudence, my lord, has to be rewritten.
Yes.
Where your lordships have in a number of judgments held that whatever is there in the pleading as well as in the evidence, the court will only look into that.
Total 44 appeals in this. We were told. Now those are arising out of the same judgment. Now how many petitioners were there in all these matters? Total number of petitioners, how many?
May I say this, my lord?
How many challenged the selection process?
140.
Only 140.
Only 140.
More than 140.
No.
Yes.
140 writ petition. Now any other person came into the zone?
No, not in the appeal, before the writ court.
No. Before the writ court we are asking. 140. All the 44 appeals, let us clear out the facts. All the 44 appeals are arising out of the same judgment. And all the appeals are dealing with the case of 140 writ petitioners. There were no other persons. Whatever application for addition has been filed is by the teachers who are already in service. Right?
Not only that, my lord, who are in the same footing of the petitioner, that application is also filed because their petition is also pending, and the board submission is that, my lord, due to this pendency of this matter, they are unable to address the court. So that's why the additional party and one of the additional party.
No, additional party. One.
My lord, can two already in the first order it is mentioned, my lord, can two is already allowed.
Into account.
Wait.
How long will you take, Mr. Dotto?
Well, at least one half, another one half.
1 hour.
One half. Half of a day. Well, I have to show a lot of judgment. First is not my judgments which I placed. Whatever judgments I have placed here has not been notable.
No. On factual aspect, do you want to take us to any other document?
Yes, there are some other documents which I need to take, Your Lordship. But these findings are not based on anything.
On 20th 2 p.m. you cannot finish. If possible, we will keep it as a continuing matter so that you can finish your argument. Prior to the vacation, at least you can finish your argument. So that now it is their turn.